Gentlemen, may I have your attention, please? The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go.
Guys, Rich just came in on his phone because he had a studio mode. Rich, how are you doing?
Good.
All right, I'm gonna put us up here. This might be a little bit easier to see everything, but we have some good news, guys. The New York zombie law is dead. But first, how are you doing down in Florida, Rich? Everything okay?
Good. Yeah, I just flew the drone over the house, did a roof inspection. There's some tabs missing, so there's going to be some work needed. I don't have
But everything
electrics, so yeah, that means no water, no AC. But
okay.
I got the inverter running, so mostly okay.
All right. Well, let's go ahead and just listen to or let's talk about what's going on. New York has something called the CCIA, which is the Concealed Carry Improvement Act, which wasn't an improvement. It was New York's response to the Bruin decision, where they made a bunch of different regulations. One of the regulations that they made was that private property that's open to the public had to put up signs saying that they allowed firearms. By the default position of the CCIA, it meant that you cannot carry firearms. Everything was gun free unless the person specifically posted signs in conspicuous locations saying you're allowed to carry a gun here. Firearms Policy Coalition sued in the Western District and said that was unconstitutional. Now a court out of the Western District of New York has agreed. This was Christensen versus James, and basically it knocked it down. Not only did it knock it down, but this is the too long didn't read version, because I know some of you guys are busy, but he also refused to stay his decision. Can you read, Rich, or do you want me to?
We could give it a try. I'm not sure how good it's going to be.
No, let's give it a try, and if not, I will go ahead and take over and read it, just to prove to people I can read. Even though I write, so pretty much whatever. I'm gonna go ahead and add this on here. You know what? I'll do a screen share over here because it might be a little bit easier for us to read here. Just gonna reposition all this.
Ooh, yeah, that's not going to work for me. I'm on an extreme lag.
I will just go ahead and read it then. Basically, a decision order, a newly enacted New York law makes it a felony for concealed carry license holders to possess firearms on all private property unless relevant property holders actually permit such possession with a sign or by express consent. So basically, they have to say, okay, you're allowed to carry here. At least as to private property open to the public. New York's restriction is unconstitutional, a result dictated by the teachings of the Supreme Court, recent addresses, addressing Americans, individuals' right to bear arms. What they're talking about is the Bruin decision. Regulations in this area is permissible only if the government demonstrates that the new enactment is consistent with the nation's tradition of sufficiently analog regulations. Now, if you remember, the Rahimi case said that a analog does not have to be a historical twin, but it does have to be sufficiently analogous or
Analogous.
analogous. Ugh. New York fails to test here. Indeed, property owners have the right to exclude, but the state may not unilaterally exercise that right, and therefore interfere with the long-established Second Amendment rights of law-abiding citizens who seeks to carry for self-defense on private property open to the public. Before the court are cross motions for summary judgment. So both sides ask for summary judgment to um, decide in their case. So this is the final step. There's already an injunction against us. This is the final step. Relevant here, plaintiffs asked the court to enjoin enforcement of the private property restrictions as to places open to the public. For reasons below, plaintiff's motion seeking that relief is granted. That would be Firearms Policy Coalition. Good job. Defendant's corresponding motion is denied. That would be New York. So that's a good thing, right? So basically, there's a guy that filed a lawsuit in 2022, Amendment Foundation, and sued the state, Stephen G. James and Michael J. Keene, who represents the state. It One, James is the superintendent of the New York Police. Basically, he has Bruin's position, and Keene is the Erie County District Attorney. So the plaintiffs challenge the three provisions of the New York Concealed Carry Improvement Act, the 22. You basically know that. Christian is a self-defense, is a concealed carrier, and wants to carry a firearm for self-defense. In particular, the law prevents Christian from carrying for self-defense in local parks or when hiking on trails while using transportation such as the Metro Rail. Christian is also unable to carry his firearm on his person throughout the state because of the state's definition of private property. So if you go to a gas station and you're carrying a gun and the gas station doesn't have a sign saying you can get gas here with a gun, then you are committing a felony in New York. It was a direct attack on the Supreme Court. Some would even say that it's the state thumbing its nose at the Supreme Court. Rob Olson
Yes.
always used to say that. So he challenged that law. The plaintiffs moved for summary judgment. Christian, a resident of Chiquikwa, New York, stated that he was licensed to carry a handgun pursuant to New York law with a license issued in Erie County. But to comply with the new law, Christian was forced to disarm constantly in places he would otherwise carry. As a result, he was left without the ability to defend himself and was suffering diminished personal safety on a frequent and ongoing basis. According to Christian, prior to the enactment of the private property restriction, he would typically bring his firearms with him on private property open to the public, including weekly visits to the gas station or the hardware store. He intended to continue to do so, but for the enact and enforcement of this restriction. Christian also stated he intended to carry a firearm for self-defense in parks and public transportation, but cannot do so in the light of the new restrictions. As such, Christian sought to enjoin the defendants from enforcing the three restrictions on the concealed carry. On November 20, On November 22nd, 2022, this court issued a decision to order preliminary injunction enjoining the defendants from enforcing the law on private property with respects to property open to the public. The court stayed the resolution of the portioned plaintiff's motion addressing public parks and transportation. The defendant appealed. The Second Circuit affirmed the decision, addressing the appeal in tandem with 3 other appeals of similar in district court orders. Antioch, which is a case that Stephen Stembolia is arguing and Rob's doing a lot of the briefs on, was granted cert and was granted judgment and vacated sub nom. So this Antioch versus James. So basically, one of the things the Antioch case is up for review at the Supreme Court. Relevant here is the Second Circuit issued a mandate on January 2nd, 2024, ordering that the preliminary injunction enjoining enforcement with respect to private property and open to the public is affirmed. The Second Circuit basically affirmed the judgment that was in the Antioch case against that. The Second Circuit concluded the state fails to place blah, blah, blah within a national tradition. That's an Antioch, which is referencing Rob and Stevens' case. If it is explained that the state's analogs fail to establish a national tradition motivated by similar how or why of regulating firearms and private property to the public in the manner attempted, although the Antioch plaintiffs petitioned the Supreme Court for a writ of certiorari, which was granted, it mandates as the writ of certiorari was granted? I'm not aware of that.
So writ of certiorari specifically refers to Supreme Court?
Yeah, I don't think it was granted, though. I don't think it's I think it's up for conference, but I don't think it's granted. Unless that happened sometime like today or something.
Right.
I'm gonna have to check that out here. I'm looking up orders of the court here. Let's see here. Murphy.
So here's the thing: when New York came up with the Concealed Carry Improvement Act, this was in response to Bruin. Thomas in Bruin wrote, like, hey, don't be pulling a rabbit out of the hat on all of these magically appearing places where you can't carry. I'm on to your BS. And
Yeah.
they did it anyhow.
Yeah, he made a very stern warning stating that.
Yeah, and dude, if we did any of this crap, we'd be in jail. It's amazing to me what Kathy Hochul and her frickin' cronies are getting away with.
Yeah, not too long though.
God bless.
Yeah, let me just search here. I don't see Antioch being granted. All right, I'm gonna have to look up. I don't know. Plaintiff asked for a motion of summary judgment, basically on the same grounds that they asked for the preliminary injunction, that the court that basically that it is inconsistent with the nation's traditions. Remember, Bruin said that it has to be first they look at the text. If the plain text of the Second Amendment covers the conduct, then it moves on to the second part, which is history and tradition. that means that the state has to provide analogs from the founding era to show that the law is consistent with the history and tradition of firearms regulations in the country. New York could not do that because, of course, they couldn't. And yeah, so they couldn't do it. And the court knocked it down. It's about 42 pages, but it basically just goes into history and what they try to submit, because what the state always does is they try to submit like racist laws and stuff. But it
That's
does
the best ever. It's
yeah.
like, no, we're racist. We didn't allow it when we're racist, so we shouldn't allow it now. It's like, yikes.
Yeah. But Rahimi is stated in there, which is kind of funny because Rahimi originally was thought to be like a lost for our side, but they keep on coming back to do where it says you cannot disarm someone permanently if they're not a danger. Another case, the range case, which is working its way through. I want to do a video on that, which is very interesting as well. In the range case, which is another case, it's very interesting because the state tries to argue in that case. They just filed a brief yesterday, and in their brief, their thing is we're not disarming people permanently forever. We're just disarming them indefinitely.
Oh, and that's a significant difference without a distinction.
We can give them back their rights, but we don't have to. All right. So the founding era, okay, New York, they try to use a Maryland law from 1715 before the founding era, 1721 before the founding era, 1722 before founding era, 1763 before the founding era, 1771, which is before the founding era, and 17 era, plus all those laws are not even relatively similar to what they were doing. They just threw a bunch of old laws that were before the founding era, because the founding era didn't start until the ratification date of the Second Amendment. But even if they did use those laws, none of the laws that they tried to use was actually from the founding era, but none of them were relatively similar.
Wow.
So, for example, the 1715 Maryland law prevented like people that's been convicted of certain crimes from shooting or carrying a gun upon a person's land. So basically, it said, okay, you're not allowed to, if you commit a certain crime, you're not allowed to bring a gun on a certain property. But we're not talking about people that commit crimes here. We're talking about concealed carry holders, which are which are
20 times less likely to commit a crime with a gun than a cop with a gun.
and the Maryland
that?
law, yep, and the Maryland law only applied to plantations.
Oh my!
Let's talk about the 1721 Pennsylvania law about carrying a gun, or hunting on a plantation.
You know you're a tyrant when you use the most racist laws on the planet to back up your point.
Yeah. So basically, they try to use this law to prevent blacks from carrying guns on plantations. All right.
Unbelievable.
Okay, let's talk about the New Jersey law from 1722. Guess what it applies to?
Black people?
Black people on plantations.
Oh my effing God.
This up, man.
What is wrong with these people? Can we insert the clip of Joe Biden about
No.
we don't need a mayor?
No, we're not. We're not going to talk about that. Okay. Let's start with the New York 1763 law. And that says no one no one shall. You are not allowed to discharge a gun in a cornfield unless you have the owner's permission.
Dude, what is wrong with these people? Oh my god.
Basically, and the law basically say you're not allowed to discharge a gun, and you're not allowed to trespass on people. Discharge a gun in a cornfield without the owner's permission, and you're not allowed to trespass on the owner's property even if you don't have a gun. So I said,
I'm just
makes
gonna
no
leave that one. Because we need to protect the corn. Corn rights matter. Corn lives matter.
Okay, the 1791 law from New Jersey, it's not a racist law, but it says you're not allowed to hunt on other people's property without their permission.
And carrying a gun in public places means you want to hunt on other people's property. The connection is how?
Yeah, I don't know. What they're trying to do is they're trying to throw anything at the wall and see.
Okay. I understand how you make that connect. Is there was a place where they said you could not hunt. They didn't say you couldn't carry a gun, but they said you could not hunt. So there was some sort of prohibition regarding firearms in respect to property.
Yeah. The Massachusetts 1780 law dealt with hunting as well on people's property. None of those really passed anything. But then New York tried to do what they always do when they can't find laws from the founding era. What do they always do? What do they always say? The founding era is not the ratification date of the Second Amendment. It is the
The
ratification date
14th Amendment.
14th Amendment, which is in 1868. Rich, what type of laws were being passed in 1868?
Ooh,
After
Jim
a guy?
Crow laws?
Yeah.
I just wouldn't go to say, hey, you know what? I'm right, and I'm right because of all of these racist Jim Crow laws. I'd
Yeah.
rather be wrong.
Yeah. So they tried
Hey,
to.
we did bad things to black people, so yeah, it makes it okay now.
Yeah.
Oof. In which party is the favorite of minorities?
I don't know, but they're the ones who passed all the Jim Crow laws, and they're the ones who wanted to keep slaves. So
Ouch, ouch.
it failed. So the state failed to meet the Bruin standard, which means that it's dead. So what the
So
state
what's
wanted,
amazing is this is a state court. This isn't a federal court, so this is still within New York State. So that's
uh,
kind of impressive, right?
no,
It's a federal court?
the federal court. It's the Western
Okay.
District Federal Court.
Okay.
Yeah.
Wow. Okay.
So sorry. So the federal government asked, Vanderstock didn't go the way that I would like it to go, but you never know what the court's going to do.
Right.
Don't read too much into it quite yet. Yeah. The state, they wanted to they requested a 14-day stay pending appeal. That request is denied.
Wow. Wow.
Factors relevant to granting a stay are the applicant's strong showing that he is likely to succeed on the merits and irreparable injury and the plaintiff's to be injury to the applicant in absence of a stay, substantial injury to the non-movement party if a stay is issued in the public interest. The
Wow.
first two factors, the most critical, but a stay is not a matter of right. Even if irreparable injury might otherwise result, it is an exercise of judicial discretion, and the party requesting the stay bears the burden of showing that the circumstances justify an exercise of discretion. A stay pending appeal is not warranted. As discussed above, the plaintiff's constitutional rights are violated absence of an injunction. The state has not established irreparable harm in the absence of a stay. The preliminary injunction has been in place since November 22nd, 2022. The balance of hardships and the public interest weighs in favor of the plaintiffs, as discussed. Finally, it is the plaintiff who has demonstrated success on the merits of the case.
Wow.
And it is signed John L. Sinatra Jr. I wonder if any relation.
Oh, that's interesting.
Buffalo, New York. So ordered.
Holy. So when do they get open carry?
I don't know. There's already been an injunction. So it's the law. It's just the law is going into effect. I wonder if this is my my new suppressor. My other one's in too. I gotta go pick it up.
Ooh.
My wit machine is in. I'm gonna go tomorrow.
Very cool.
Yeah, they're fast, man. Processing is crazy. But yeah, that is all. It's not a change because there's already an injunction. It's just more harder for the state to get back. Oh, so unknown wants to know where he can get birdshot cap gun. I think she meant that any gun that shoots birdshot is not a firearm, and you're allowed to own it without going through any type of background check or anything.
But that's not a thing either.
A birdshot cap gun?
That doesn't exist.
Yeah, I know. He's making fun of the Solicitor General.
Right. Yeah.
Although I do think that she did a good job, which sucks.
Reasonably good job. Yeah.
Yeah. All right, guys. That's it. Just wanted to make you.
Can I do an ad read?
No. I'm just joking. Go ahead.
DefinitionKnives.com launched. We are live. We have credit card processing, everything. That is Dark's company and my company, DefinitionKnives.com. Please take a look at the website. And that's it.
Yep. And I just want to remind everyone to be sure to check your wiper fluid. And
spay and neuter.
No, just check your wiper fluid.